legal research methodology, tools of study, mens rea, through case analytical study towards judicial precedent, judicial activism, international court of justice systems. Like Enoch Arden says, the dead man come to life again, beguiled his wife no more dot dot dot. Like this novel, in 1889, Lord Halsbury, he was at the chancellorship of the court. Justices Denman, Field, and Manisty, and Barons Belloc and Huddleston all thought that it had have been decided the other way. These five dissentients were overruled by the nine other members of the court. The whole then strength of the Queen's Bench division, with the exception of Mr. Justice Matthew, afterwards Lord Justice Matthew, were upon the bench under the presidency of the late Lord Coleridge, the Lord Chief Justice of England. Henry was the counsel for the prisoner who had been convicted of bigamy. This is the case. Henry was counsel for the prisoner who had been convicted of bigamy. Now we are going to legal analytical studies by the legends or predecessors. The jury convicted the prisoner, stating, however, in answer to a question put by the judge, that they thought that she had, in good faith and on reasonable grounds, believed her husband to be dead at the time of the second marriage, and the judge sentenced her to 1 day's imprisonment. Now, the leading predecessor counsel, um, Henry, enters. The question turns upon the construction of all the sections um, which become later statute for bigamy was first made felony and removed for the cognizance of the ECCLESASTITCAL ecclesiastical courts. It is difficult to believe that in 1603 the legislature intended that the man or woman remarrying under the bona fide is reasonable to believe, otherwise should be liable to capital punishment. This is the spirit of this tools of study. It is true that the legislature may, for its own reasons, dispense in any given case with the necessity of a mens rea, and may constitute certain acts crimes in themselves, but this is generally done in very clear languages. Once again, I repeat this. This is the tools of study or a case analytical study as in court of record. It is true that the legislature may, for its own reasons, dispense in any given case with the necessity of a mens rea, and may constitute certain acts crimes in themselves, but this is generally done in very clear language. He then, Counsel Henry then cited Coke upon Littleton, Cockins' plias of the crown, and terms de lay did felony to show that a person cannot innocently commit felony. I tell the once again the bibliography of Counsel Henry. Littleton 39 1a. Hawkins' Plias of a Crown, Book 1, Chapter 25. and Termus de la Ley did. All this bibliography council establishes felony to show that a person cannot innocently commit felony. It's a leading eye opener for the mens rea. Majority of the court decided uh, until that as a prisoner is the uh, alleged charges. But after this argument, how true this is may be seen upon reference to the story told in the case of Westwood versus Chettle, related in the Law Times for the 5th January 1895 on page 228 under the title Alive or Dead, which shows that even a conclusion formed supervisum corporis supervisum corporis, it shows that even a conclusion formed supervisum corporis may be erroneous. For in that case, an unhappy woman saw the 9 days dead body of the man she supposed herself to identify as her husband, and yet reason was found afterwards to question the correctness of her supposition. It must also, however, be remembered that nothing can make a second marriage in such a case good or children of such a second marriage legitimate, not even if the 7 years have elapsed. The view of Sir Henry Calkins was also that of Lord Coleridge and of the Justices Stephen, Cave, Day, A.L. Smith, Wills, Grantham, and Charles, and the entire legal research methodological eye opener of mens rea was won by Henry, whose name will probably be associated with this victory as long as the law of England, or as long as the rule of law all over the world exists. Yes, um, yeah, an advocacy for a prisoner's liberty has been won or succeeded under the shadow of Council on Record Henry's banner, such as non est res nisi sit mens rea. In this case only, it is true that the legislature may, for its own reasons, dispense in any given case with the necessity of a mens rea, and may constitute certain acts, crimes in themselves. See, in Pets versus Amstead case, 20 QBT 771. But the settled principle precedent is evolution towards the rule of law through this legal research, such as non est res nisi sit mens rea. Otherwise, it is true that legislature may, for its own reasons, dispense in any given case with the necessity of a mens rea, and may constitute certain acts, crimes in themselves. NON, non, EST, est, REUS, res, NISI, nisi, SIT, sit, MENS, mens, REA, mens rea. Non est res nisi sit mens rea is established by this council Henry for prisoners' liberty regarding felony imprisonment, bigamy imprisonment. Then liberty or justice is conquered. Justice for the aggrieved is plugged by this rule of law. Rule of law is a evolutionary, scientific, dynamic process. I thank all the predecessors of the juries and law all over the world, and wishing all the legal aspirants go ahead, rule your own arena. Thank you.